All right, it is 10 o'clock, and I call the meeting of the Michigan Board of State Canvassers to order. Director Brader, has the meeting been properly noticed under the Open Meetings Act?
Yes.
Thank you. So I heard on my way here this morning that a number of schools are dismissing early because of anticipated weather, and we may want to dismiss as early as possible also, but we have important business to consider. The first order of business is consideration of the meeting minutes of the February 3rd meeting. Do we have a motion?
Madam Chair, I move to approve the minutes of the Board of Canvassers meeting, Michigan Board of State Canvassers meeting held on February 1st, 2023.
Support.
It's been moved and seconded. All in favor?
Aye.
Opposed? The motion carries. The next item of business is consideration of the.
I'm sorry, but we had public comment. I think we had one person who wanted to speak on
Oh, do we
public
want
comment.
to? Okay, so we can, we have public comment from Mr.
Yeah.
Yes. So you have 1 minute to address us.
Hello?
And I will time you.
Hello, are you there?
Go ahead.
Okay. Well, thank you for your time here. James Gallant, Marquette. I wanted to thank you for establishing a 1-year approval time for the ADA accommodations. And I believe the Attorney General had an opinion last year, and she had several other recommendations. I don't know what all the policies you made, but one of them was that she appeared to think that bodies were supposed to make a standardized form so people could apply for accommodations for to participate. And I don't know if you have that available, but if you made that, other bodies could then create ones that others could, then adopt, which would be great. And please investigate the current practice of your local county canvassing boards who certify elections with a majority of one political party certifying the results in direct contradiction to Article 2, Section 7. Simply says there shall be no majority of either party on any canvassing board. And they did that in Marquette, and Lansing did that also, in Ingham County did that. I attended both those meetings. And also in Lansing, Ingham County, they also they gave the oath of office to 2 extra canvassers that day. There were 6 canvassers. The Constitution in that same.
Thank you for your comments.
Same article
says have adopted an ADA policy. And,
well, I know that, but
okay. Complying to the extent that we can with the guidance from the Attorney General's office. So thank you for your comments. Okay, the next item of business is the consideration of the 100 word summary. Director Brader, do you want to tell us about this proposal and the summary?
Yes, happy to do that. Do we have someone from Michigan Justice Advocacy here? No, okay.
I do not believe so.
So I'll just note that we don't currently have anyone from the Attorney General's office here. I don't believe that we need to proceed, but if there are legal questions, we will not have their benefit of those at the time being. So if the board wants to pause at any time to wait for them to get here, we can obviously do that. With that said, this is our first 100 word summary of this grouping of the Board of State Canvassers. The summary in question has to do with changing sentencing practices in Michigan, and it was sponsored by Michigan Justice Advocacy. The proposal essentially would do away with the truth in sentencing law, which was passed, I believe, in the 1990s, that created mandatory minimum sentences, which could then be extended either for disciplinary time for misconduct or reduced by earning certain types of credits. And that's what the current law is. This would repeal that structure, and it would allow prisoners to earn up to 30 days a month off their sentence for good time credits. And the good time credits, instead of being based on specific proactive positive things, would be earned by not having a major misconduct, which is a series of a number of things that are laid out in the regulations that mostly have to do with violent or dangerous activity. It would also it would apply to people with their current sentences. So it wouldn't just be new prisoners going forward. So that's what I tried to capture in the summary. The 100-word summary is drafted. How many words is it? I'm sorry. It's under 100. I know that is, I'll just read it, is initiation of legislation to repeal truth in sentencing law and eliminate mandatory minimum sentences extended by disciplinary time for misconduct. Allow prisoners to earn good time credits that reduce sentences by 30 days per month. In each month, a prisoner is not found guilty of a major misconduct such as violent or dangerous activity. Apply law retroactively to all prisoners in the Michigan Department of Corrections.
Any questions for Director Brader?
I have one question. Director Brader, when you first introduced it, you used the term up, or you used the term up to, I think, up to 30 days per month. And here you're using the term by 30 days per month. Should that say up to, or is it or goodbye?
I think it's by. I don't believe there's anything in the proposal that specifically delineates reducing those 30 days to a different number. So I think that would be the most accurate way of describing it. It's possible that in an implementation, and again, to be clear, I'm not an expert on sentencing policy in Michigan, but I believe that in implementation, it might be possible to have some other measures like that, where the 30 days could be reduced to something more than 0, but fewer than 30 days.
So it's either 0 or 30 days.
Director Brader, we are not approving this petition to form. They are only asking for the summary draft, correct?
That's correct.
Do we have any other questions? Okay. I downloaded, when you sent us material, Mr. Fracassi, I downloaded a copy of the petition and I didn't bring it with me. Do you have some copies there?
The only copy I have is the one that's in the packet. They have not given me a physical copy or anything like that, but I'd be happy to, if you want me to pull it up and show you.
Well, I looked at it and it certainly looks like a reasonable summary. No other questions?
And there was no other
Any further
documentation
discussion?
from anybody else?
That is correct.
And there is nobody here appearing for the Michigan Justice Advocacy. And nobody for the Michigan Department of Corrections either.
Who would have normally been here to represent that? You said the Attorney General's office is.
Well,
The petitioner,
The petitioner or the,
Okay.
So
Michigan Justice Advocacy.
okay. Typically, the sponsor of the petition will come and weigh in on the summary that I draft before you approve it or change it, to either say, we like this, or we would like these changes. And then sometimes if there's an opponent for the petition, they will also come and say, we don't like the way this is summarized.
So it would have been
we think it
Justice Advocacy that would have come.
Yeah.
Okay.
Mhm.
Have you had any communication with them, Mr. Fracassi?
I've had some just to submit the petition. They were aware that the meeting was today. Beyond that, I've not heard anything one way or the other.
they're aware that if there is any defective form, that any signatures that they do collect after, or they do collect in their time, could be challenged if the form is incorrect.
Correct. They have indicated that they are planning on seeking approval as to form. So I anticipate that we will get the petition as well as like the printer's affidavit and all that at a later date. At a minimum, they still, even if they don't want the approval as to form, they still have to file the 15 copies with our office before they can even begin circulating.
And is their plan to put the summary obviously in the petition?
Yes, they have to.
Right. That's probably why they're not asking for approval to form.
And has this summary has been sent to them, is that correct?
On the agenda, yes.
Yeah.
Yes,
So they are aware of that.
I believe so, yes.
Okay.
And it will be sent to them with whatever the board approves today will also be sent to them as well.
Anything further, board members?
So we approve this. If we approve this wording and then they come to us in annoyingly say, you know, we actually don't like this. We would like to have this changed a little bit. There's nothing stopping us from doing that, or would that create some issues? I mean, frankly, I'm not inclined to take their concerns into consideration, given that they couldn't show up to this meeting for this. But just as a concern.
Yeah, so I think the election law assumes that if I draft and the board approves a summary, that the drive will use it. It doesn't specifically contemplate what happens if they then use a different one. And again, the Attorney General's office will be here any minute, I believe, to possibly weigh in further on that. But I don't think anything would preclude the board or me from drafting and approving another summary if they came in and asked for one. And then similarly, if they used a different 100-word summary that they actually circulate without getting that approved, it'd be a legal question as to whether they could use that. I think the way I read the law, they could use a different summary if they wanted to, but they would not have the safe harbor of being someone not being able to go before the board and say the petition should be rejected on the basis that the 100-word summary is misleading. If you approve the summary, you cannot then consider a challenge that it was misleading in the future. Only a court could do that at that point.
One more question for you along that same vein is if we don't approve this, that would mean that we reword this and then approve something, or does it mean we simply don't approve anything?
Yeah, in the past, what we've done is if the board wants any changes, we talk about them, and then I'll draft in a modified version, which the board will approve.
The goal being either way, when we leave here today, something has been approved with 100 words.
That is what we have always done. Yeah. Yeah.
The one question I have, and my apologies for not completely being 100% prepared on this question, is your summary says that they're repealing the truth in sentencing law, when the petition, what they had kind of drafted together was a petition to reinstate a good time behavior program. So is this petition repealing the law, or is it instituting a good time program in the Michigan Department of Corrections?
So my understanding, again, not being an expert on sentencing reform and policy, is that the truth in sentencing law was a bill that was passed in the 90s, which changed what was previously a sentencing regime that was more similar to what this petition has, and replaced it with mandatory minimum sentences that can be extended or reduced based on the categories of issues that are currently in Section 33. And so basically this would undo that. And so that's where the repeal truth in sentencing language comes from. I'll also note that we did have a different petition involving sentencing changes. That was not exactly the same as this. It worked differently. It had more specific types of credits you could earn. But that also did away with kind of the truth in sentencing framework. And on that one, we had on the 100-word summary to repeal the truth in sentencing law. So I thought it made sense to do the same thing here.
I guess my only question on that one is just more of general understanding of people may not know exactly what the truth in sentencing law is, like general public, but they think that they would understand a good time, reinstate a good time program. I think, I don't know, I'm kind of talking out loud on this one because I'm just going through what they had put on here and then putting in that truth in sentencing law. But if we're, I think what we're supposed to have, commonly used, that's the only reason I'm bringing that up is I'm just trying to, I don't know if anyone else is thinking the same way I am in a little bit, but I'm not criminal justice either. So
if the truth in sentencing law repealed the good time procedure or policy, then would it be accurate to say repeal the truth in sentencing law and reinstate the good time provisions of sentencing. I can't find the
I think,
provision.
I think that would be accurate. I'd have to go back and look at whether they were called good time credits prior to the truth in sentencing law.
There you go.
That's where, I think that's why I'm asking the question.
Mhm.
The reinstate a good time program.
What Michigan Justice Advocacy put on their petition that they submitted is a petition to reinstate a good time program. So in their opinion, that's what that's what this petition would do. I do not know offhand whether it was called a good time credits program prior to truth in sentencing. I have to look that up.
This is all, I'm just going off the bat. Section 11. All references to disciplinary credit or disciplinary time in Michigan compiled laws are hereby stricken. That's, I'm just trying to use the wording that's in the petition because that's what we've used a lot and we've used that as kind of the definition of what they've actually submitted to us. So that's where I didn't see truth in sentencing. So that's why I was asking that question, because we have had that conversation when we're talking about summary. Specifically, I think when we've done definitions, like if the petition itself has worded something a certain way, then we've allowed that in the summary. But if it wasn't, that's not what we accepted. That seems about right. To certain petitions that have been in front of us.
I think Director Brader and the team have done a good job with what they've been, and I think all of us agree to that.
Mm-hmm.
Where I am right now is it's March 2nd, 3rd. I don't see a rush, and I don't want us to rush into approving something if the advocates aren't here to assist us with questions of what their intent is. I think this is, my initial blush is, I think this is bad policy, but that's not what we're here for.
Mm-hmm.
We're here, is this clear and state the summary, and without the intentions of the advocates of the policy to kind of make sure we're understanding what they're doing. I don't see a need or a point in moving forward on approving this today. Not saying we shouldn't continue talking about it.
Yeah.
It does concern me that we'll rush into it and then there will be concerns that we got wrong.
And I think that they'll come back in front of us for approval to form, most likely with those, going back to what you had said, going back to those changes. And for me, if they were asking for approval to form and this was not the summary, I would not allow, I would not vote for a conditional approval to ask to form because it's not on the petition. Which goes back to, and I know, Tony, you and I, you were here for that. So, but do we have a timeline that this has to be approved? And it looks like Adam is shaking his head yes. So what happens if we don't approve this?
There's not a specific remedy, but I mean, the election law requires the board to approve it by March 7th.
Is
For the
this,
summary.
Oh, so there is a timeline.
so this was the changes made in the legislature. And I can't remember which year that was now.
18, I believe,
Yeah.
at the effective 19, January 19.
So that's why we,
Yeah. So
So we could not table this. We need to act on this. Is that your conclusion?
yeah.
and I guess what's the recourse if that was, if this board was not to approve your language, what happens?
Well, so do you want to just read what the election law says, Adam?
Sure. So it's
Yeah.
it's section 482B. So it's 168.482B as in boy. I'll skip to the relevant part. It says the Board of State Canvassers must issue an approval or rejection of the content of the summary not more than 30 days after the summary is submitted.
Okay.
Does a rejection trigger?
Anything else?
It's the same as a tabling, correct? if we trigger a rejection, we don't have to rework it here. We can leave that to you folks and bring it to the next meeting. Is that the?
Or is it a total rejection?
I would say the law is silent as to that, as to what happens. I can read the entire section if you want.
Yeah, and sorry, we had a miscommunication. I think the AG's office believed this meeting started at 2. So that's why no one is here at this
I'm
moment.
sorry that they believe what?
They mistakenly believe this meeting started at 2. I'm not sure how that happened. We'll try to figure out how that happened so it doesn't happen again. But someone is on the way, but I'm not sure exactly when they're going to be here.
They're here, they're on their way now.
Yeah.
Could we simply put this to the end of the agenda and revisit when they get here? If it's before 2?
Yeah, if the chair
Good
wants to
idea.
do that.
Can I make a motion to temporarily move agenda item number 3 to
Agenda
the,
item number 8.
to agenda item, to
Make it a number.
when the AG representative is here.
Perfect.
Okay.
Support.
All right, all in favor?
Aye.
All right. So we will move on to okay, statement. Agenda item number 4. And on this item, we have Thomas Whitener, who has asked to speak. So if you would come to the podium.
Thank you for the opportunity to speak.
Mr. Whitener, will you spell your name and for the court reporter? Please?
Sure. Thomas Whitener, ThomasWhitener.
And will you raise your right hand and swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Which is petition number 1?
So this petition, the language on this petition
Okay.
says concerns were raised about Treasurer Whitener's job performance after a backlog in the
Okay.
processing of receipts was discovered by the Kalamazoo County Commission. Whitener was unable to resolve the issue to the satisfaction of all county commissioners.
Okay, Mr. Whitener, so we have 2 petitions to consider. So if you would first address yourself to this one, and we will discuss it, and then later we can address the second.
Thank you. I'd be happy to.
And you have 3 minutes.
Yes, ma'am. So petition number 1, in my opinion, fails on both the tests of factualness and clarity. The factualness of it is, in my opinion, pretty obvious. It is based around a series of opinions from 9 individuals, which cannot be known at the time that the petition would be circulated. It attempts to capture the internal processes of their mind, and that is only an opinion. As far as the factual nature of it, it is not factual. The backlog in receipts, which did exist at one point due to a software transition, that backlog was resolved and has been resolved to this point. So the statement to my view, is neither factual nor clear as to the reason for or the continuing reason for recall.
Thank you. Any questions for Mr. Whitener?
And Mr. Faust is not here, correct? Another instance.
Yeah,
of
nobody else has requested to speak.
People so desperate to have their issues considered, they can't even make time to show up for things. Thank you for being here.
Absolutely.
On the issue, the second part you raised about where Whitener was unable to resolve the issue to the satisfaction of all county commissioners. Is that true or factually correct that there were county commissioners who, despite your resolution, what you did to resolve it, they still were unhappy?
Well, I am a member of a political party, and so are they. I think that they will be unsatisfied with anything I do ever. But I would not deign to know the internal processes of their mind.
Mr. Widener, I mean.
Yes, sir.
Let me just read this sentence, then I'll make a statement. Widener was unable to resolve the issue, satisfaction of all county commissioners.
Hmm.
That implies all county commissioners. How many county commissioners weren't satisfied?
I wouldn't know specifically.
Do you know if some county commissioners were satisfied?
I would imagine that there were. I have spoken with a couple of county commissioners who said, you know, we understand that you're working through a difficult time and believe that you're doing your best.
So was there a county commission meeting at which your purported resolution of the issue was discussed and addressed?
There have been several.
The question as to factual comes down to the use of the word all, I guess, right? You could take the word all and it could mean.
It could mean every county commissioner across the state of Michigan. If you want to be
Suggests unanimity
charitable.
to me.
Yeah.
But if, Mr. Whitener is saying that he doesn't know what some of the commissioners thought because there was no vote or meeting at which there was some, obviously we're grappling with what happened with the county commission and trying to understand whether there was some particular event or occurrence which would support the assertion.
Right. There must be notes, there must be proceeding notes.
There would be meeting minutes. There was no vote of no confidence or anything clear that there was nothing like that.
There was not?
No, there was no official vote of no confidence. I've been asked to appear to give reports, which I've happily done, and I'll be doing again next week on the Treasury office and how we do our business. But they have not taken action that would indicate significant disapproval of the way my office has functioned.
So there's no official record, if I'm understanding, that would add credibility or make it factual for that last statement.
I would have to refer you to the meeting minutes to look at those. Unfortunately, I don't have those and I don't have them memorized. So I don't want to, as I swore, I don't want to speak incorrectly.
To my colleagues, is there's nothing in this meeting, no person and no document that demonstrates that last statement is factual. There's no proceeding minutes. There's no.
Mr. Cassie, there was no documentation, correct?
Correct. I have given you everything that I have received.
I don't have any further questions for
Mr. Dunn.
Mr. Whitener.
I'm trying to balance the issue of allowing voters the ability to recall elected officials that they are unhappy with, whether we agree or disagree with their reasoning. This seems like it's addressed to a job performance issue, something that occurred in office. And that there were, in my reading of the second part was that, yes, some of the commissioners were happy about it, but not all of them were. And so I think that's just a difference of how we're reading that sentence. And that lack of clarity. So again, I think it's important that voters have the ability to recall their elected officials or to attempt to recall their elected officials for a variety of reasons, as long as it's something that they've done in office. But also, if the individuals seeking the recall aren't dedicated enough to come to a meeting to answer the questions of the people who are charged with approving the language, I find it hard to move forward without those, this same with this past issue, the justice advocacy, without the people advocating for these things, it's difficult for us to understand what we are approving as being factual and clear. They're not here to answer our questions. So I've talked myself into being opposed to this.
Madam Chair, I don't believe any of us have any questions for Mr. Leitner. We might be able to, that way we can,
Okay.
he's not standing staring at us.
Thank
At least I don't have any questions.
Okay, so,
But I mean, to Tony's point though, I mean, this is the second petition, right? And then it's a third.
yes,
When we've had recall petitions before and at least the individual either made accommodations or submitted documentation or anything of that. The all is concerning to me. That is concerning.
Factual, but I've got a problem with factual because it can't be demonstrated as factual, and I've got a problem with clarity because I don't.
I'm still trying to figure out where the concerns were raised. I mean, because it says concerns were raised and then was discovered by the Kalamazoo County Commission, but it's not. It lacks, there's some clarity here that needs to be in the wording. You know, but we can't, one of the things that's always difficult in these conversations is that it's not that we can tell you what you need to fix, but
We shouldn't be telling.
no, that's the harder part of.
This one, this recall language is now fundamentally different than what we reviewed and voted on last time. There's been some word salad here, but that's about the end of it. It still has.
that's what they usually
It
do.
still has, but it still has the, there's still a question of factual to me, and there's
Right.
still a question of clarity.
Right. My problem is that I simply cannot judge the factuality of these assertions based only on what's presented to us.
Yeah, it's a, yeah.
Okay.
And what is the reflection of actual satisfaction?
Right.
I'm sorry.
What determines what is actually satisfaction for all?
Well, I think that right now, for us to review this, if Mr. Faust had been here and had brought in some official document like minutes from the county commissioners or even a statement from one county commissioner, at least it would give us a baseline to have a discussion. We have none of that.
It's not laid out very clearly, I guess.
We're almost at a point here where I guess it almost, when I read this and Mr. Faust isn't here, the Whitener has just made his case. It's almost like we should start it out and say, let's pretend. And that's not what we should be doing.
So it is our obligation to determine whether we think it is
Factual.
and clear. So do we have a motion?
In a moment, there will be. I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Paul Faust against Thomas Whitener on February 15, 2023 are not factual and sufficiently clear.
I think you need to clarify which one it is.
Petition number.
Petition number 1.
For reasons because
it's not factual and clear.
It is difficult to understand the reasoning being put forward for recall. Does that make sense?
yes, I just wanted you to clarify so I could say support.
We want to be clear about our lack of clarity.
Because we do have to have the because, and I don't think it can be because it's not factual and sufficiently clear.
So we have a motion. Do we have a second?
It was, I supported.
Okay, all in favor?
Aye.
Aye.
Motion carries. Do you have that sufficiently, Mr. Fracassi?
I believe so. And it
Okay.
is on the record as well, so I
All
can capture it from the court reporter as well and verify for the minutes. Thank you.
And Mr. Wagner has asked to speak to petition number 2.
And just for the record, the wording on that is Treasurer Whitener appointed Michael Boudrum as his deputy treasurer. Mr. Boudrum had little experience in matters of public finance when assuming the position and ended up resigning after job performance issues arose.
Thank you again. Hopefully I won't be up here too many more times in front of you, but while it is true, I appointed Michael Boudrum as my deputy treasurer, and he served in that capacity for some time. The petition is not clear as to why that is a basis for recall. The language included in the petition, to my ears, sounds like a normal hiring and firing process. My office does things other than accounting. We process the foreclosure. We're the foreclosing governmental unit for the county of Kalamazoo. We process dog licenses. We do all sorts of other things. Michael Boudrum was hired for expertise outside of the accounting side of things because I have expertise for accounting inside my office, specifically my chief deputy, who has 35 years of accounting experience. Michael was hired for other reasons. The petition gives no reason as to the conduct that is a basis for recall. Again, in my opinion. So while it is factual that I hired Mr. Boudrum, that he served in my office, and that he resigned under threat of termination after the job performance issues arose, I don't see that as a clear reason for recall.
Questions for Mr. Wagner?
Just one. Again, go to the last sentence, and ended up resigning after job performance issues arose. The established, what's trying to be established here is that his resignation was the direct result of his job performance issues that are being brought up here. Yes or no? Is that the truth?
Yes.
He resigned.
He resigned after his job performance issues arose, and I asked him to resign.
So that is a factual statement.
It is a factual statement.
How about the statement that Mr. Boudrum had little experience in matters of public finance when assuming the position? Can you tell us what his experience was?
Mr. Boudrum was a project manager and an entrepreneur. He was experienced in managing of people and large, complicated projects, as well as being a small business entrepreneur. So he did have experience in finance in his own capacity.
Any other questions?
Not from Mr. Wagner. No.
Did appoint him to serve as your deputy treasurer.
I did.
That's factual and that's clear.
That is factual and clear.
And he ended up resigning after job performance issues arose. That also is factual and
Yeah.
clear.
That is factual. The clarity, in my opinion, goes to why that's odd when an employee has job performance issues.
So, okay. So one more question. So that's all part of one sentence. Mr. Boudrum had little experience in matters of public finance when assuming the position, and therefore ended up resigning after job. Was it his little? I mean, was it his lack of public finance experience that led to the issue?
No.
I'm assuming that because this is a human relations personnel matter, you can't discuss what led to the issue.
I would prefer not to.
So had little experience in managing public finance when assuming the position, concluding that that ended up and that's why he resigned. Not correct.
That is not correct.
Anything, any other questions? Do you have
No, I
any
don't have any questions for him.
Member Don?
General conversation, but not directed towards Mr. Light.
Okay.
Thank you.
Discussion?
Sentences. The sentence is misleading. It's tying the fact of little experience in public finance when assuming the position to resigning because of job performance. Am I reading it wrong?
But is misleading the same thing as non-factual?
Well, that's right.
Yeah.
I think it's silly, as a lot of these are that come before us. But it does seem relatively clear that these are things that happened and that are factually correct. And you know, we don't want to make it impossible for recall petitions to succeed. You know, I'm inclined to support this one because, you know, again, it's pretty clear what's the reasoning, whether I agree with it rising to the level of being someone that somebody should be recalled for. You know, I view recall as, you know, so-and-so voted for
On this
House
date,
Bill,
that's
you know,
very clear.
4089.
Yeah, there's no opinion in there.
Right.
That's
And our role is strictly to review it on factual and clarity.
right.
The word factual was added to the statute a couple of years ago.
Okay.
And I think it's difficult to understand what that is supposed to mean. There's a case,
Especially
Hooker
because
versus Moore, which we discussed last time.
Mhm.
And it says, and I think this is helpful language, in ordinary usage, the word factual can mean restricted to or based on fact, while the word fact can be understood to mean an actual occurrence and a piece of information presented as having objective reality. So it happened.
Okay,
Right.
but I go back to one thing. Can I ask Mr. Whitener one more
Of
question?
course, Mr. Whitener.
It's a redundant question.
That's fine.
The fact that's being stated here, that's being implied here is because there was little experience, because there were issues with the public finance knowledge that this gentleman had, that was the reason for the job performance. Was his resignation for job performance issues?
Mhm.
You can't tell us what those issues were.
Without Labor Council present, I would be uncomfortable discussing that. But I can tell you that his lack of public finance experience and knowledge is not related to the job performance issues that resulted in his resignation.
You know, years ago, I had a fabulous programmer who worked for me. From the standpoint of knowledge, he was positively brilliant. He had one slight problem. He couldn't get along with other human beings.
I have worked in the software industry. I know the type.
So
Is like public office now?
well, with all the remote work, you can find. The problem is, in other words, so when he was dismissed, you could make the argument, well, you could tie those two sentences together. And I guess that's the question I'm asking you is that the experience in public finance and job, it's not even experience in public finance. He resigned because of job performance issues. Were those related? Was it related at all?
To his experience in public finance? No.
question to you folks is, does that create a question of clarity? Or does it create an issue with fact?
I think it's clarity. I'm sorry, because it says that little experience. If I read this as a general public, I would make the assumption that he resigned because he had little public experience, public finance experience. There wouldn't be a connection, right? Like that's would be my assumption reading that.
That is, I think what you're saying is that you think that this suggests that it is his lack of public finance experience, which creates
it's an
job
opinion.
performance issues, right? And that's what you're suggesting. You want
I'm
some
saying that
connection between the two.
I truly believe that the right to recall and the process that we're going through here is really important.
I do as well.
honestly don't know what your role is in Kalamazoo, whether it's good, bad, and different. I don't know if you can balance a checkbook. That's not my problem. But my issue is that while we are going through this argument, these are really serious things. We approve this and the petition is put out and people begin to collect signatures.
Mhm.
Real things can happen to real people, not just you, but also to the people who are the voters in Kalamazoo. So if we approve this, that means that you and Mr. Faust are going to be out arguing one way or the other with your constituency. I guess my question here is, if what we're approving is either misleading or not factual, or is really not clear, then we are not doing anything that's going to benefit the voters in Kalamazoo. We're putting them in a spot where they're going to have the same head scratch that we are. Is that a true statement?
Or come up to the same opinion of that lack. Yeah, there is no doubt that the first sentence of this petition is factual and clear.
Absolutely.
Phrase.
Yeah, that first one.
Phrase.
Yeah, the first.
It's all one sentence, which is what.
No, there's a period after treasurer.
Period.
Oh, okay.
Yeah. So the first
Period
sentence
after treasurer.
clear.
Sorry, right.
Second sentence, not as clear.
It's the second one, and it's the way the
Right.
sentence is constructed and what's implied but not stated. The implication is very clear that because of little experience in
Mhm.
public finance, that this gentleman ended up resigning. And it's what's being said is that the little experience in public finance is the cause of the job
Job
performance
performance
problems. What I hear you saying is, Mr. Whitener, is that is not true.
Correct.
And Mr. Faust is not here to present the other side of the case. Let me ask you a question. Would Mr. Faust, if he were here, would he have the knowledge to know what was in the personnel record?
I don't believe so, but at this point, I don't have that information.
Okay.
But I don't think that truth is what we are supposed to be
No,
judging
no,
here,
we should be
right?
judging by fact.
Clarity and factual. Right. This case suggests that they can be untrue facts, but I think that that is the most ridiculous conclusion. It makes me think of Kellyanne Conway and her alternative facts. And I don't want to base our conclusion on that, but I think what I'm hearing is that there's a lack of clarity in that second sentence, which is certainly puzzling us. And Member Hauskamp, I think you're right that it would not. We need to be concerned about whether it would be clear to people who may be asked to sign petition. So,
Yeah.
How important is clarity?
it's essential. No, clarity is what we're supposed to determine.
Yeah, that's right. And you said that was the original.
Right. And factuality was added. But truth is excluded.
Mr. Don, do you feel like it's crystal clear?
I see the argument being made about the implication of the experience in matters of public finance being the reason for the resignation. But I don't believe it's fatal because it's still a factual statement that he did have little experience in public finance matters. And so ultimately the issue is the recall is being sought because this individual disagrees with the judgment of Mr. Whitener. I don't, in my personal opinion, don't think something like this rises to the level of, attempting to recall. We all have made poor choices in hiring decisions over our years, I'm sure. But ultimately factual and clear. To me it is, but I feel as though I'm in the minority on this, so.
Well, I mean, there's two things being stated, right? And that's kind of where the clarity issue for me is, is that one, if we're going on what is written here, Mr. Budrum had little experience in matters of public finance when assuming the position. Okay. And then the other one is, and ended up resigning after job performance issues arose. Okay. There's two different, for me, the thing that's only clear to me when it comes to, are we talking about Mr.
You're right, you're spot on, because that's exactly the problem here is that when you bring the clarity in, to me, it goes backward on the factual, because if this gentleman resigned for whatever reason, job performance or whatever reason, that was his choice and it's on his shoulders. However, if you tie it to the no prior public experience or experience in public finance, it becomes a matter then of his hiring was a question of Mr. Whitener's judgment. I think the clarity ends up affecting.
So
the
you're
fact.
putting, so we have three phrases here. And
Yes,
the
and we're
question
putting
is how
together.
those get put together.
If it was a little bit, if there was a little less information, I guess, that
It would be more clear.
it would be more clear.
Mhm.
Do I agree that someone would just write, okay, they appointed and the person resigned is why someone should be recalled? We've had that conversation about, is it factually clear to say, Richard wore a red tie on, on March 3rd. Therefore, we feel he should be recalled. Does it have anything to do with the office? I guess that's where I'm at.
That was something that we discussed last time.
Yeah.
Because it does, each reason must be based upon the officer's conduct during the term of office. So here we've got the officer's conduct, and we also have the conduct
Of the
essentially
individual.
of somebody who the officer hired.
That's why I say this is either, this may just be a poorly written petition language, but it could also be that this is being obfuscated with a motive, with an agenda. And I've got a problem that I don't know that weighs into the issue of clarity, but I think sometimes clarity can be used. Clarity can be used for a whole lot of reasons, right? Maybe this is just poorly worded, but
the wording is what we are called upon to evaluate. So it is what it is. I hate that phrase.
thanks for answering the question.
Yes,
Happy to do it. Thank you.
thank you. Any further discussion? We have a motion.
Would you like to make this one?
Try. These are not always the easiest motions to make. Okay. I'm trying to figure out how I want to put this. I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Paul Faust against.
Second. You say second. Sorry, we should put that there for you.
Yeah, I'm sorry. I'll redo it again.
It's our fault. Sorry.
I'm usually third time's the charm kind of person, but that's okay. I move that the Board of State Canvassers determine that the reasons for recall printed on the second petition submitted by Paul Faust against Thomas Whitener on February 15th, 2023 are not factual and sufficiently clear because the language goes to three different points of
It's misleading.
No.
The three different points and therefore does not make it sufficiently clear. Yeah. Tried.
Support.
All in favor, right?
What did you
We need support.
Oh, okay, I'm sorry, I didn't. All in favor?
Aye.
Opposed? Okay. The motion carries unanimously.
I can tell you as the board member that has went through the first recall hearings back during the Snyder recalls. These are not the easiest meetings. Yeah.
It's really a challenge, and having represented people who were the targets of recall in the past, when the only question was clarity, it was very difficult. And conclusions were drawn, which were completely inconsistent with each other by different election commissions.
Madam
So,
Chair, may I ask?
Right, clarity is, I don't say it's in the eye of the beholder, but it is a difficult determination to make.
And I was on the fence on this one for the reasons I laid out. I think from a board perspective, having us all indicate that so that people who pay attention to this know kind of where we are on simplicity is going to be the most clear language. And the less opinion related commentary made, the better off you're going to be moving forward.
How many signatures does the were needed for this in Kalamazoo County?
So for this, the signature threshold is based on it's 25% of the last vote for governor in the targeted district. So in this case, Kalamazoo County. Long story short, sponsor would need to gather 29,194 valid signatures and submit them. It's a 60-day window that they have to be gathered in.
It is a very formidable task. That's an understatement, right? All right, so we have completed agenda item number 4, I think. My computer keeps closing down. No, that was the conclusion for agenda item number 5.
We're on the discussion.
And so we are back. Oh, we are on number 6.
Mhm.
So you want to present to us, Director Brader and Mr. Fracassi, some proposed changes in the guidance for petitioners and challengers to petitions with regard to how the validity of signatures is determined. Is that it?
Correct.
Madam Chair, do we want to go back to the issue we set aside until AG got here, the AG's office got here, and then go to this to make this discussion the last piece? But I only bring it up for.
Or should we make him sit through the whole meeting?
I'm here now.
I mean, I can make the motion to go back to item number 3.
I support that.
Okay, all in favor?
Aye.
Okay, back to number
Thank you,
3.
Kelly.
We have a question for you, Mr. Grill. So we have been asked to approve language drafted by Director Brader. There is no one here to answer questions that we may have about that language. We were uncertain about whether we had to either approve it or reject it today, or whether we could table it to a later date.
And what happens if we
And what would
reject it?
happen if we did?
The proposed language from Director Brader at the meeting today rejected a petition under the.
No, the language,
Summary.
the word summary.
So looking at section 482B, it states the Board of State Canvassers must issue an approval or rejection of the content of the summary not more than 30 days after the summary is submitted. What the effect would be if the board does not approve or reject within the 30 days is unclear. There is not a case I can find that this has come up. So defaulting back to plain language and what that means, the board must issue an approval or rejection of the content of the summary not more than 30 days after the summary is submitted. what the effect is. What happens if it doesn't?
If it says the board must, that's mandatory language, which
So
does not give us the option to table it. Am I correct?
there are sections of the Michigan election law that state that if the board does not act within a certain time period, it's treated as a rejection. This particular section of statute doesn't include that language. So this would require probably some construction from a court to try to reach that. It's not impossible, but it's not clear from the statute that that's the intent or the effect.
If we were to reject it, does that mean that the language that Director Brader has put together, and we're not saying that it's bad, that's not it, but we had some questions. Does that mean that that language would be set then? Or no, no?
I'm not sure I understand
I
the
don't know.
question.
I mean, if we reject it, is it rejected altogether?
It would be a rejection, but I don't think that would stop the board from reconsidering a subsequent proposal. But the time limit of 30 days still is in the statute. Does that make sense?
That makes sense, but
There has to
But
be,
they could submit it again.
I was gonna say, what I hear you saying is that within that 30 days, there has to be a 100-word summary.
so if we were to reject it and they submitted language again, that would start the 30-day window again?
What the statute provides is that let me just read through it again quickly here. The person who circulates a petition under 482 may, before circulating any petition, submit the summary of the purpose of the proposed amendment or question proposed that is required under section 423 to the Board of State Canvassers for approval as to the content of the summary. The Board of State Canvassers must issue an approval or rejection of the content of the summary not more than 30 days after the summary is submitted. The Board of State Canvassers may not consider a challenge to the sufficiency of a submitted petition on the basis of the summary being misleading or deceptive if that summary has been approved before circulation of the petition. So if the board meets as it is and rejects the content of the summary within 30 days, then that is a rejection. Then the petition circulator or proponent could submit a new proposal.
I would say, just for practical purposes, if there's a summary, there's no guarantee that this group will come back next time if we schedule a meeting to consider another summary. If the board is able to get to a place where it's comfortable with a 100-word summary, that would be the most efficient use of our time, in my opinion. I will say I am not particularly invested in the reference to truth in sentencing, if that's what's causing confusion. I did do some searching, and our state Department of Corrections has a website in which it says that truth in sentencing is a 1998 state law, which eliminates disciplinary credits, good time, and correction centers for certain offenders and requires offenders to serve the entire minimum sentence in prison prior to being considered for parole. And it says various other things. So that's the aspect of truth in sentencing, that's the sense in which truth in sentencing would be repealed here, because it would be reinstating, I suppose, these good time credits and also doing away with that mandatory minimum to the extent that sentences can be reduced by 30 days per month of non-bad behavior. So I will say I do think there's some value in referencing truth in sentencing. I would say that if that's the concern and we can work through some changes to the summary, I'm happy to propose an alternate summary for the board to approve. And again, I based on Mr. Grill's summary, I don't know what it will be if the board rejects this. I don't think we've ever had that happen before. Perhaps they'd come back again and it wouldn't end up being an issue, but I don't know what would happen.
If we take a 1-minute break.
Oh, yeah, of course.
You're the chair.
You're the chair.
Put us at recess.
We are in recess.
There we go.
2 minutes.
You can find the truth in sentencing online. Just wondering, I'm not opposed. I just wanted to have the conversation. You know, unfortunately, we don't have the sponsors here. We don't have anyone who would oppose. So we're just looking at the wording, and I'm not saying that the wording is just trying to like everyday language. And that's why I brought up the question of the truth in sentencing law, is unless you are criminal justice or if you have been involved, you would understand. I mean, if you asked me what the truth in sentencing law was, I can't tell you what that is. That's kind of where I went with that, but.
But what we're saying is that repeal the truth in sentencing law, which eliminated the good time program essentially, right? So.
That's right.
It was essentially, I mean, it was kind of the tough on crime era of you do something, you get sentenced to 3 years in prison. It shouldn't end up being 1 year and 2 months because of good behavior in prison. You need to save those you need to serve those full 3 years. That's essentially what was being addressed with these types of laws. To me, it's clear that it's repealing that law and eliminate where I have a question, eliminate mandatory minimum sentences extended by disciplinary time for misconduct. Is that saying that under truth in sentencing, what they're really addressing is that there's in truth in sentencing, it was 3 years. But also if you were doing bad things, it was extended beyond the 3 years. Or is it just getting rid of, does it still allow for additions to your time in prison and reduction in your time on the minimum? I don't know if I'm clear in my question, but.
Are you saying like, does it eliminate extra time if a incarcerated individual does not behave correctly?
Correct. Thank you.
It's right there. It's the donut. Thank you.
So,
But part of it seems to me what is a question of whether this is affirmatively saying that this is a restoration of good time, the possibility of good time reduction of your sentence, or if it's the way it reads here, it's pretty negative. So it repeals truth in sentencing and eliminates. Where it says, allow prisoners to earn good time credits. It seems to me that I have a question about whether that is the most important part of it, which should be highlighted rather than the repeal truth in lending, which doesn't help people very much. I mean, this is supposed to be neutral, right? And that's kind of hard. So we're dealing with two concepts: repealing a really negative law and restoring something that's more positive.
No, I have the
right?
same question, because if I read them aloud, right, the actual wording of the actual petition says initiation of legislation, a petition to reinstate a good time program in the Michigan Department of Corrections. But what we're doing in the wording is we're saying the same thing: initiation of legislation to repeal the truth in sentencing laws. I understand how you're connecting those. I'm still a little bit cloudy on. To me, reinstating a good time program in Michigan Department of Corrections, and repealing the truth in sentencing law, are those equal?
I think to the extent that a good time program is reinstated, it is repealing truth in sentencing insofar as truth in sentencing required a mandatory minimum sentence be served, which this now would not, other than the terms of your original sentence would provide some, lower limit on what you could serve. Because if you've got a 50-year sentence, you still, I think the way I understand this working, you'd still have to serve at least 25 years of that. Because you could only get 30 days per month, basically, off your sentence. But so that is the sense in which the truth in sentencing would be repealed. It'd basically be reversing that mandatory minimum aspect and replacing it by reinstating the good time credits. Now, again, as I noted, I don't think it's absolutely necessary to mention the truth in sentencing law or the phrase truth in sentencing here. I do think that it's important to explain the change. So I think, explaining that this replaces the current system of a mandatory minimum that can be extended by disciplinary credits or disciplinary time, I should say, and replacing it with a good time credit program is important, but I'm not wedded to a specific way of phrasing that. And I'm definitely open to different wording. The board thinks that would be more clear.
But a judge still would follow. I mean, when you think of repealing the mandatory sentencing, that goes way back, that goes even to prior to day one in prison. A judge is still going to follow mandatory sentencing. This has to do with the behavior of the convicted individual while they're in the institution, right? Those just seem to me to be different things. A good time program for getting time off your sentence doesn't necessarily equate to the fact that you were handed a mandatory maximum sentence. Right? Or am I looking at that wrong?
No, I think it does.
That's honestly beyond my expertise to answer. I don't understand the details of sentencing to be able to answer that question for you at a technical level. My understanding of the way that the truth in sentencing law established mandatory minimums was to require someone who was convicted to serve the minimum portion of their sentence before they could be released. Whereas previous to that, even if the minimum sentence was 2 years, if you got credits for a good time, you could get out earlier than that. You get it after, a year and a half.
But it does touch on that.
So the focus of the petition as it is drafted here, with the title, a petition to reinstate a good time program that allows the prisoners to earn credit. That is addressed in your second or third phrase, right? Allow prisoners to earn good time credits, the reduced sentence. It seems to me that it would be, I guess the question is how it is most accurately portrayed in accordance with the way the petition itself is drafted. So that the fact that the effect of this is to repeal the truth in sentencing law, which eliminated mandatory minimums, would be better at the end of it rather than at the beginning in terms of how it's perceived and what the impact is. So we just.
I think if this does repeal the truth in sentencing law, that needs to be the first thing we address. Right? I mean, that's a pretty solid statement of the fact that that is what it is doing.
But is it, I guess the question I have is, is it repealing? I'm sorry, I'm trying to read it
Repealing
small.
portion of the truth.
That's what I'm saying. Is it repealing the whole law or is it only repealing section or amending section 33? Or, so I'm not.
So again, straining or going well past my expertise, I think that truth in sentencing basically is section 33. I don't know if any of it is reflected in any other section of the criminal or justice code.
So that goes back to a different question. If we were to reject this, then we would have more time to research it. Is that it?
But we don't know
Or-
what the
or
consequences are if we reject it.
Correct. That's the mystery part, right?
Yeah.
But what are I guess the other thing is, it goes back to Tony's point in the beginning, which is we approve this because we are under the 30-day time constraint. And the sponsors decide that this summary is not correct or they want to change it.
We have
And yeah, so we've done it before. So we've changed wording before, but we haven't been at this window before. We haven't extended this window before.
What, does it repeal the whole truth in sentencing?
That's
law?
the question that I have.
Yeah, I don't know.
I don't know. Does
Because
our
I
Attorney
don't
General
see anything
represent?
in here that says it does that. Does it say that?
Mr. Brader, can I ask you a different question?
Sure.
What if would you be willing to let us put in like to repeal portions of or aspects of the truth in sentencing law? And we just, if we weasel word that just a tiny bit,
But we don't know, do we?
we don't know either way, whether it's repealing the whole truth in sentencing law or whether it's repealing.
Right, we don't know.
Mr. Grill, do you know?
That's
Well, I'm outside of my expertise in sentencing as well. I primarily do election law, but it's probably worth pointing out again, the last sentence of subsection 1 of 482B, which provides that the Board of State Canvassers may not consider a challenge to the sufficiency of a submitted petition on the basis that the summary it being misleading or deceptive if it was approved by this board before circulation of the petition. So if you approve it now, there will not be a challenge later on if language was misleading.
Right, but if we, the bigger question is what happens if we reject it now?
Yeah.
Because we're too confused about what it does. Is that essentially requiring the petitioner to come back and clarify things for us, or even to allow you and Director Brader to research the sentencing procedures for the or law for the Department of Corrections?
The board has the authority to approve or reject the summary. Obviously, if it approves it, then there is no further review later on about whether it's misleading or deceptive. But if it's rejected, then it's rejected. There is no prohibition against coming back again with another summary.
So we could reject it and it doesn't.
Right.
It doesn't preclude them from coming back. I mean, it's like I view it like the recall stuff that that we reject these people on recall and they come back again and again until they finally get it right, or they just give up.
I think that's where I'm at, is that if we reject the wording because because it seems to be a consensus on us here what does it exactly do? When we're trying to, I guess the question is, if we remove the truth in sentencing language and we go to however Director Brader has that, I would be willing to see what Director Brader has. Are you just talking about repealing that sentence, or are you restructuring? What were your thoughts?
Well, based on the discussion, I mean, I think it could say something like repeal portions of truth in sentencing law that created mandatory minimum sentences extended by disciplinary time for misconduct. That would be safer, because whether it's all or part, that's still accurate. So, it could be repealed portions of truth in sentencing law that established mandatory minimum sentences extended by disciplinary time for misconduct, and then the rest could be the same. I think that would address the concern about whether it's repealing the entire truth in sentencing law.
Are you okay with that?
That sounds sensible.
Mm-hmm.
It also sounds sensible for these people who put these things forward to show up to meetings and explain to us why they're doing this. I'm going to beat on that horse till it's at the glue factory, but that's none of our problem here.
No, but I mean, that's the alternative, right? Is we could buy
Is to
that, we could
reject
reject
it,
this and
yeah.
they have to come and read.
And help us.
read it.
But we don't really know if that's what would happen,
Right.
So what if they don't?
because you can't tell us exactly what would happen. You said if we either can approve it or reject it. Now, we've never rejected one, but you can't exactly tell us what happens if we reject this draft wording.
I think historically what has happened in the past is the petition proponent is here, and then there has been some back and forth with the board about what the board would like it to read. And then there's an agreement that is subsequently adopted.
Right.
But in the absence of that, the board's option is to either approve or reject.
I do think that although there is time right now for this to get worked out, I do think the practice of I will not take it personally if it's rejected. But the practice of rejecting, I do think it creates some problems for us down the road when there is more time pressure on approving these things because the petitions want to get out fast. Like I don't necessarily think it's likely that this would be a lawsuit here when they could just come back, but that practice could get the board in more litigation going forward. But that's really a question for Eric.
Aren't you glad you came, Eric?
Sorry.
Every day.
Are we allowing them enough time to come back and resubmit it? We aren't taking away. Again, I'm gonna go back to the fact that there's people way outside of our province who have a vested interest in this 30 days at a time. So the bottom line here is that we're not taking away the opportunity for them to come back.
That's
before
my
this
question.
Next cycle, right?
For the next cycle.
Well,
This is really early in the petitioning cycle,
We
so.
can still come back and we can still go through this and we can still get the right word. If we reject this morning, this group that's trying to put this on the signatures on the ballot, to get something on the ballot, still have time to come back and.
they would. I mean, they may be trying to circulate in the summer because their goal may be to get the legislature to pass this since it's an initiated law. But which is what happened like with the Unlock Michigan. But yeah, I mean, there certainly would be time before the next election cycle.
One more question related to that. Are we, if we reject this morning, will one of the outcomes be that these folks have less calendar time to collect signatures? Will this delay the process of collecting signatures?
Yes.
It will.
Because
Because they'd have to wait another 30 days or whatever it would be where they could, well, assuming they want to use language approved by the
they have a
board.
certain amount of time to collect signatures, right?
Right, what is the window for that?
So they have 180 days. So when they submit, we look back 180 days for that validity.
Right, so they haven't, so they're always gonna have 180 days,
Mhm.
right? So that doesn't reduce their time. I think what you're addressing, Director Brader, is whether they would want something that could go to the legislature. But that could be any time this year, right?
Correct, yeah. This would
So,
not prevent them.
so they're probably not disadvantaged by, if we were to reject it today, and they read the transcript and understand that we needed their help and they weren't here, they could come back.
Yeah, they could. I think, the way it would disadvantage them is that if they were planning on starting right away and they wanted to do it this summer, this would cut a month off that. I think a more situation where a petition circulator or sponsor would be more disadvantaged or troubled is if, say, they were coming in with language about 180 days before the deadline. And they're planning to use that 180 days before the deadline and make sure they had that entire period to circulate. Cutting 30 days into that would be a much more serious hindrance to that type of effort. Because now by the time something gets approved, if they want to use something the board approved, they would then only have 150 days to circulate before the deadline. Here, they wouldn't have that problem, but I do worry about the board getting in that situation. If a 100-word summary can't be approved in the future.
If the rest of the summary here, the rest of this 100 words reads fine, right? And it's clear, it's laid out well, it summarizes it well. If we put in the word portions of, if we reword that first sentence, make it reflect portions of as opposed to like simply repealing the whole truth of sentence.
I'd be okay
If we
with
did
that.
that, would you be okay?
I'd be okay with that. I think what it comes down to is we don't have anyone representing either opposing or sponsoring, which makes it difficult. And the legislature putting in a 30-day requirement doesn't really assist us at times too, but.
Director Brader, are you comfortable with that or?
I'm sorry, I was distracted.
Rewording that.
Oh, yes.
Instead of repeal truth in sentencing law, repeal portions of.
Yeah, I would propose repeal portions of truth in sentencing law that established mandatory minimum sentences
Okay.
and then keep the rest the same. And then we can print that out and show it to you.
That seems to me to emphasize the repeal rather than to emphasize, as they seek to do in the petition, the reinstatement. I mean,
Well,
and so it's just a question of whether this is, we're supposed to be neutral when we come up with something so that we're neither suggesting approval nor disapproval. So I'm just not sure if I look at eliminate or repeal the truth in sentencing or part of truth in sentencing, I think that might affect my perception of it much more than if it just says reinstate good time.
are you looking at putting, instead of have an initiation of legislation to allow prisoners to earn good time credits that reduce sentences by 30 days per month, and each month a prisoner is not found guilty of a major misconduct such as a violent or dangerous activity, repeal portions of the Truth in Sentencing Act that eliminate mandatory minimum sentences extended by disciplinary time for misconduct, which would also go to apply law retroactively to all prisoners in the Michigan Department of Corrections?
That seems to me more neutral. And more consistent with the way that the petition itself is drafted.
I have no opinion on the order of the clauses. If there's a order that 3 or more members would vote for, I'm happy to put it in that order.
That's the first thing it says. People of the state of Michigan enact, except otherwise provided in this section, for each month in which prisoner has not been found guilty of major misconduct, the prisoner must receive good time credit in the absence of records or behavior. I could read on, but I'm not going to. That's what the beginning of it is.
Without the repeal,
But
No, but
is there
it would be,
anything
but it's
in
just to be second. It wouldn't be the first thing, it would be the second thing.
is there anything in the petition itself? I'm not seeing it, although there's a lot of small print, that refers to the truth in sentencing law.
I didn't see anything that referred to that. That's why I asked the
yeah.
question in the first place.
Right. So where did you get that from, Director Brader?
The repeal,
Yeah,
it's just the effect of it.
but you know that that's the effect of it because, not because it says so, but because.
Essentially, I mean, because as I noted previously, when there was another provision or another initiative petition that the board approved 100 words for, that also changed the truth in sentencing law.
Oh, okay.
We had, the board had used that framework. And so I just carry that into this one, honestly. Like we had a different one about 2 years ago, which didn't do the good time credits, but did create other types of credits that could reduce sentences. And that one started with repeal truth in sentencing. Now, I believe, if I'm not mistaken, that in that case, the petition sponsor had actually recommended including that, which is not the case here. So that's a difference. But just to try to be consistent with how the issue is handled in a similarly, in a petition with a similar effect on current law, I carry that language into here. But again, as I noted, I'm not really that tied to that wording.
You know, given the nature of the public right now that we've watched in the last couple of election cycles, that just off the top, if I were walking into the Kent County Public Library and the table was set out front and all the petitions, like signatures are there, and I were to read this 100 words saying to repeal truth in sentencing or even portions of truth in sentencing. Now we're to look down the page on the petition that says to reinstate a good time program. I would look at that and say, that's not the same thing. Are we setting something up here where you're going to deny people who would normally sign this petition, who would say, I'm not going to sign it because these two things are contrasting each other? Not wording.
Yeah, I mean, I think this is, I think, always a challenge when we have initiative petitions for initiative laws that change the effect of other statutes or eliminate other statutes that are not expressly listed in the wording. And often, you know, this is where it is beneficial to have opponents and proponents talking about that. Like we went through that a lot with some of the election law related ones. We went through that with some of the, like the reproductive freedom petition and had the effect it would have on other current laws. So I think, if that's my timer, I'm happy to stop. But But the balance there is not confusing people by referencing statutes that aren't in the petition, but also making sure that they understand the effect of it on current law, even if that current law isn't spelled out in the text. So again, that is where I thought it made sense to carry forward the similar determination that the board and I made with another sentencing reform petition. But I think there's multiple ways of handling that that would both be not misleading or deceptive. So
Is this exactly 100 words?
no, it's well under 100 words.
So we actually have the room to put in there something to the effect of reinstating a good time program and repealing portions of the truth and sentencing.
Right.
You'd still be under 100.
Yeah.
And those are both there. It's just a question of which phrase
Correct.
jumps out at you.
Yeah.
Right. And the way the petitioner phrased it is a petition to reinstate a good time program, so it makes you feel good about good time, right? As
Yeah.
opposed to repealing, and I don't know which is good or bad, but
Well, you can get both. If you're under 100 words, you still.
right, you can have both. The question is where the emphasis is placed, right? So, Adam is doing it right now. I can see.
So are
Right.
you drafting up a
He's doing,
change in the order,
Are you-
or is that what you're?
I'm
Go ahead.
playing with something.
Okay,
based
go
on
ahead.
what,
Yeah.
Vice Chair.
Possibly
House
changing
said.
the-
Okay, let's see how that reads. Yeah.
So
Okay,
at least it's
disappearing.
so
something like that.
well, the truth in sentencing thing would need to go down farther, right?
If we want to change.
Well, remember asking, were you proposing to start with reinstate good time credit program and then go directly into repeal truth in sentencing, or to move that farther down as Chair Gerwitz had suggested?
I'm open to either one.
Okay.
If we just,
Okay, so I see. Yeah, I mean, I guess that's not redundant necessarily. So this would be, this would reference good time credits multiple times, but not necessarily in a redundant way, in my opinion. And we have the words. So this would be initiation of legislation to reinstate a good time credit program and repeal portions of truth in sentencing law that establish mandatory minimum sentences extended by disciplinary time or misconduct. And then the rest would be the same.
that's, to me, that's a clearer.
Although I would, if you're saying reinstate good time, then I would follow with some explanation of what that is before repealing truth in sentencing and explaining what that is.
So
Because
yeah.
then you get confused with the elimination and
So we could say initiation of legislation to reinstate a good time credit program that allows prisoners to earn good time credits that reduce sentences by 30
Right.
days per month, and then take that out where it is farther down.
And to do this, I don't know if you would say and repeal or by repealing that part of the truth in sentencing law, which eliminated mandatory minimums.
I think and would be a little bit more precise because it's not only taking the language out from truth in sentencing, but it's also adding language
Okay.
that describes how the good time credits work. So this formulation would be, I think I can do it. Initiation of legislation to reinstate a good time credit program that allows prisoners to earn good time credits that reduce sentences by 30 days per month. In each month, a prisoner is not found guilty of a major misconduct such as violent or dangerous activity, and repeal portions of truth in sentencing law that establish mandatory minimum sentences extended by disciplinary time for misconduct. Apply law retroactively to all prisoners in the Michigan Department of Corrections.
Sounds good to me. Is it in the Michigan Department of Corrections or the custody of the Michigan Department of?
Yeah, I mean, I use the word in because I didn't want to try to describe the jurisdictional boundaries of that. But my understanding is basically if you
Well,
are,
certainly it's only people held in Michigan prisons and not
yeah,
federal prisons.
yeah. I mean, I think I could add system if that's helpful in the Michigan Department of Corrections system.
Right.
Would the board like it to print that out and circulate it so you
Yeah.
can look at it? We have a faster printer now for those of you who are legacy members. So yeah, do you want to, Adam's just going to look this over. Maybe do we need 5 minutes or?
Yeah.
Okay,
Okay, we're going to take 5 minutes. We'll print it out.
okay. So we're adjourned for 5 minutes.
Recess.
Right, I'm sorry. You know, for years I represented the So
Are we back in?
back on the record.
All right.
I'll just read into the record what the revised proposed summary is. Initiation of legislation to reinstate a good time credit program that allows prisoners to earn good time credits that reduce sentences by 30 days per month. And each month, a prisoner is not found guilty of a major misconduct such as violent or dangerous activity, and repeal portions of truth in sentencing law that establish mandatory minimum sentences extended by disciplinary time for misconduct. Apply law retroactively to all prisoners in the Michigan Department of Corrections.
Have any questions or further discussion?
You good? Somebody want to make a motion?
I'll make the motion. I move that the Board of State Canvassers approve the summary of the purpose of the initiative petition sponsored by Michigan Justice Advocacy as drafted by the Director of Elections and presented by the Director on March 3rd, 2023.
Support.
All in favor?
Aye.
Opposed, none. The motion carries.
25 more words.
He's a man of few words.
I've never heard that before.
Okay, the next subject on our agenda, item on our agenda, is consideration of proposed changes in coding for determination of the validity of signatures on petitions.
So to be clear, we're not asking the board to vote on anything today. And we are going to have another meeting on March 20th when we're going to talk about some proposed changes to the random sampling procedure. But we wanted to break it up because this is a lot and we didn't want to throw too much information at you. What we'll ultimately be asking the board to vote on is approving the new manual or manuals for petition circulators in which the board's policies as to how it counts signatures will be expressed. And our goal with all of this is to update, modernize, clarify, and expand the explanations that are given to petition circulators to reduce the extent to which any disagreements, conflicts, or legal challenges are based on a misunderstanding or miscommunication. I'm sure we will still have disputes. But today, I just want to walk the board through some of the changes that the Bureau recommends when it comes to the reasons that individual signatures or sheets are rejected. And the way that we code those by writing 2 or 3 letter, 1 or 2 or 3 or 4 letter codes on the sheet. The major goal of this, most of these changes actually have to do with just simplifying and clarifying the codes we use so that they're more understandable both for our staff and also for petition circulators and those who may be challenging signatures. So most of these examples are just eliminating some codes where we had some that were very similar to each other and could arguably overlap to just condense those into one thing and then provide an explanatory comment. There's others that we think actually conversely, we need to add codes to cover more specific situations. We want to change the name of some of the codes just so they more accurately and precisely describe what we are doing with regard to a signature. And then there's some instances where we actually recommend change to practice to count some signatures that previously would have been rejected. So, I'm not going to read the whole memo for you all. But I do want to, unless you want me to, I'm happy to. But I just want to sort of go through the codes that are listed in the memo and briefly expand on what we're talking about there. I will note, and this was shared with the public, and we're hoping to get public comment on it. But I will also note that not every code that we currently use is discussed in this memo. But the full list, the proposed updated list of all the codes we use is on a chart at the end of the memo, along with some examples of sheets where we would apply these codes.
Director
Yeah.
or Madam Chair, question for the director.
Yeah.
Is this, in your opinion, do anything to enhance or inhibit the challenge to signature process or rehabilitation of signature process, or is this completely neutral in that regard.
I don't think it would change what the correct outcome would be with regard to a challenge or rehabilitation. I mean, except for a couple of places where, you know, if these are adopted, there'd be some signatures that are counted that previously were not. I think what it would do, hopefully, is reduce the number of invalid, like challenges that are not actually based on a valid reason to challenge. And potentially it might cause petition sponsors to not attempt to rehabilitate things that they can't actually rehabilitate, because hopefully they would better understand the reason why it's being rejected. And then hopefully also, to the extent that anybody did want to challenge the board's practice before a court, this would more clearly and squarely frame the issue so that whatever they think the board is doing wrong or that the Bureau staff are doing wrong could more easily be summarized by everyone and understood by the court. So that's, now I should say, to give you a sneak preview for next week, we do think that some of the changes to the random sampling process will make the challenge process much more streamlined by reducing phases, like phase review phases that kind of give us 2 rounds of challenges. So I think that will actually, again, not necessarily enhance or restrict challenges, but give us a bit more time and a more orderly process for getting challenges. But that's more about, I think, the sampling than this set of.
Through the chair to Director Brewer, has this board ever approved the manuals, and does this board have the authority to do so?
The board has approved the manuals before. I would defer to AG's office on whether they have the authority to do so. I think from our perspective, it's helpful just to have that done so that we know the board understands this. For bureaus, Bureau of Elections role in staffing the board, we would like to know that what we're doing is what you want us to be doing. So that's the benefit for us of having it approved. But Eric is, I think, doing some
I
quick
think
research.
the other question is obviously this board is not, that I'm aware of. I know that we have discussed this, but not the current makeup of the board. That the board has not been through a promulgated rule process. Is this something that we're leading to, or is this just policy of the board? Sorry.
This would be, well, Eric, do you want to answer that? It's kind of a legal question.
Yeah, I think we've looked at this in the past. I'm not aware that the board itself has promulgation authority. I think that has to go through the Secretary of State derivatively process. What was the second part of the question? Was there a second part of the question?
No, that was actually,
that was it. Yeah.
that was a clarity. Clarified my original. No, and you were saying that we have approved the manuals before. When was the last time that we approved the manuals as the board? Please don't tell me it was during my time and I just don't remember.
I think it was in the early part of 2021. Is that right?
Oh,
Or was it before that?
There was one before that as well. I know in 19, I think.
Yeah, we typically, well, maybe we didn't, if we didn't change the manual. I don't know. I know we did it at the beginning of 19. I remember that. The beginning of 2021, admittedly, is a bit of a blur.
Yes.
For reasons that I don't want to rehash right now.
Yeah.
But we typically try to have the board approve the manual at the beginning of each 2-year cycle.
Trying to remember. Yeah, I think you're right. It's just all a blur. It's been a long time, so it all blurs together for me at times.
Do any of these changes address issues created by judicial decisions?
Yeah, I mean, I think some of the practices that we have are based on judicial decisions. And I think that some of these changes do, well, for example, the first one references some discussion in a judicial decision about the reason we reject these signatures. But in general, I mean, that would probably be a separate memo that we would need to prepare for you with the AG's office. But some of the codes that we have and the reasons that we accept and reject signatures are based on the way courts have interpreted the election law with regard to specific types of signatures. So I can just try to do a quick overview of these changes, highlighting the most important ones. So the first one is probably the most important in terms of a change to a practice, which is the dual jurisdiction code. So the reason that we started rejecting, the Bureau started rejecting a dual entry. So for example, when someone writes Williamston Ingham, where the person signing it probably means to say, I live in the city of Williamston in Ingham County. That's probably what their subjective intention is. We reject that currently. And the reason for that is there's two jurisdictions in Ingham County that it could be Williamston City, or it could be Ingham Township. Similarly, if you write Detroit, Wayne, you could be talking about, you're probably meaning to say, I live in Detroit City in Wayne County. But from our perspective, you could be saying you live in the city of Wayne or the city of Detroit. Where that really stems from is in the past, before we had the qualified voter file, the Bureau would have to go to those jurisdictions and ask them for copies of their voter registration records so that we could find that voter signature and the registration information and determine if they were registered in that jurisdiction. And the idea of trying to do that in 2 or 3 different jurisdictions with the time we had available, it was just not practical. And that's why if someone didn't write a single jurisdiction, the signature was just rejected because the signer hadn't properly specified where they are. Now, although it still does take us a long time to look up signatures en masse, it's not really that hard for us to find somebody, even if we have to look in 2 municipalities. So our view would be, in cases where somebody does write like an Ingham Williamston or a Wayne Detroit, we would not reject on that basis, and we would consider them registered as long as we could find them in one of the jurisdictions that's within the proper jurisdictional boundaries of the form circulated. This did come up in the Hague case last May. This was one candidate. He was, I think, running for Congress. I'm not sure, but he had a lot of these dual ones.
Mm-hmm.
And so that he was not the only candidate affected by this, or he was not the only one affected by this, but this one did go to court. And so it's just a recent example of how this can be a problem. So our recommendation would be, and again, don't need a decision today, but would appreciate feedback, would be to just stop rejecting these dual ones and get rid of this code.
That makes sense to me if you want comment, because you want to reject as few as possible. You want the citizens to have the right to have their signatures recognized if there's a good reason to do so, and not rejected if there isn't a good reason. Right?
Would you like me to go through all of them, or and discuss each one in turn, or kind of read them all through and then have discussion? What's better? What's the board's preference?
Good question.
I think probably each one with any comment.
Yeah.
Okay.
It's easier to remember.
So the next change we're looking at is just getting rid of a code. The kind of unfortunate code RAT, R-A-T, which we have used to clarify, like, where somebody is registered. They're not registered at the address they gave us, but they are registered at a different address within the jurisdiction. We've always counted those as registered because they do live in the jurisdiction. But we don't think we need a separate code for that. We think we can just write R for registered and then put in the comment, found at a different address within the jurisdiction. And also, we don't really like writing RAT on pieces of paper. So that's, just a simple, I think a pretty simple, just condensing 2 different acceptable signature codes.
So that would be like if you had someone that is that's moved a couple times and they live in one municipality, but they just have a couple different addresses. They're registered, but maybe they were in movement, or is that kind of,
Yeah.
and then it hasn't really caught up to them yet, I guess.
Yeah, a classic example of this would be somebody who, they just moved within Lansing 2 months ago, but they haven't updated their driver's license or registration yet. So they sign it, we look it up, we don't find them at, Allegan Street where they live now, but we do see that they were registered that their current registration is, on Kalamazoo Street. So it doesn't really matter that they aren't currently registered at the address they wrote on there because they are still registered within the jurisdiction.
Your chair, can I ask a general question? I didn't get it in beforehand. How are you putting this out for public comment?
We posted on the website with a meeting notice. Encourage people to comment on it.
Just the meeting notice? Or is there any other means that you're trying to, I'm just asking.
Adam, do you want to answer?
Sorry, Adam.
No, you're fine. So we did email it separately with the meeting notice when it went out. We emailed the PDF version of the memo itself and said and gave that to our regular subscribers list, as I'll call it. And it is on our website in addition to that as well, just a link on our website.
All right.
And I'm confident that all of the lawyers that you typically see before you are on that subscriber list.
Well, sometimes we seem that we really should be talking and educating the general public when specifically for anyone who, and I usually tell everyone to, if they have any questions about petitioning, they should be looking at the Secretary of State's website and under the elections, is because if you're a volunteer that's circulating petitions or that's why I asked that question. I mean, if it's only going to those who would normally be coming in front of us, then I know that, most of the chairs have been very, generous, allowing me some time to kind of explain. I mean, that's why I asked, because I feel that sometimes the general public needs to have a little bit more information on that. And if we're only going to the same people that we would normally see, we've seen in the last couple of meetings where people haven't been to this meeting, don't really understand the role and what actually happens. That's all. I've said before, if I take the last 2 years of my term on this board to educate, I will educate as much as I can. So.
On the rat issue, and I think it gets to maybe the OC as well. So you move within Lansing, you're going to be fine. But if you move from Mason to Lansing and you sign for Lansing, but you only find in Mason, that's invalid. That is rejected. Correct?
Is that correct?
Yes, that is correct.
Okay.
And that's statutory.
Correct. Yes, and that is board's current practices.
Right.
The crosses the boundaries of where that petition was legitimate. If somebody puts an address on that's right on the borderline, but they're on the other side, you would validate it?
So if it's, I'll use what member Don's example with Lansing versus Mason. If there's a couple of things going on with that. So if Mason is the post office city, that's okay. There's a number of jurisdictions like that where the specific jurisdiction might be one thing. Delta Township, for example, Delta Township can be on the petition. Lansing could also be on the petition because this is the mailing address for this jurisdiction. Where though, in the example that member Don just gave, where somebody moves from, if they write Lansing on the petition and we look them up in QVF, the mailing address is Mason, the physical jurisdiction is also Mason, that would be an invalid because you haven't signed in the jurisdiction in which you're registered to vote.
Okay.
Makes sense.
I think with that, we've probably talked about the OC example, but that's basically, if you're outside the city or township, we had a specific code for that. These are still going to be rejected, but we just are going to condense this into the invalid city category. The city that you gave or township that you gave here is invalid as pertains to this petition. So we would just condense that. Moving on, also condensing, we currently have a incomplete and no signature code, IN and S. We just want to get rid of these and other things where the signature is bad and just combine them all into an invalid signature category.
What was the purpose of that beforehand?
I don't know. I don't know. We didn't have an invalid signature category previously, so we would usually just call those miscellaneous, which I think
Mhm.
sometimes cause confusion.
Yes.
And so I guess the IN and NS were meant to provide a little more specificity as to why the thing was being rejected, but I think just calling them all invalid signatures is probably going to be more clear. And I think looking at the signature itself, someone will probably be able to tell, I mean, unless it's one that just doesn't match, someone will be able to tell if it was invalid, you know, because there's no signature there at all, or if it's part of the signature. So the next one, this is another one that's kind of similar to dual, where we're recommending the board change its practice a bit. So we currently have, we currently use the invalid city or township IC code where somebody puts the name of a village or an unincorporated place like, you know, Okemos or something, as opposed to Meridian Township. We will reject in these cases if they put a village currently, if they put a village or unincorporated place that spans multiple townships. They put one that is entirely within a township, we won't reject it currently because we know what township they live in. But if they put the name of a village or unincorporated place that spans multiple jurisdictions for the same reason that we rejected the dual ones in the past or currently, we would reject these two because we wouldn't know where to go to find the signature. But again, with qualified voter file, we can look them up. And even if we have to look in a couple of different townships, we're going to be able to find them if they're registered there. So we would propose if somebody does put their village or unincorporated place and we find them in one of the two townships, we would just count them as registered and we would stop rejecting on this basis. So that's the recommendation there.
Director Brader, can I ask you a question?
Yes, sure.
There's a theme that's screwed there, which is a great theme. It seems to be a theme that's relying more and more and more on the use of the qualified voter file.
Right.
It's a two-parter. One is, are you currently using qualified voter file that heavily? Two is, if we're gonna switch where more and more emphasis is on the qualified voter file, is up to date, accurate, audited. How do you guarantee the same level of authenticity of the old style of having somebody go look it up?
Well, I mean, the qualified voter file is what we use for all registration purposes at this point. I mean, we do still have each local clerk still does have a MasterCard, a paper master registration card. But that information should all be in qualified voter file. If it's not, then the clerk has made a mistake. But if there ever were a dispute, we still have the ability, like if somebody wants to challenge and say, well, you rejected me this signature because the person's not in the qualified voter file, but I went down to Lansing and I looked at their MasterCards and this person is registered. They just hadn't put them in qualified voter file. That would still have that option. But overall, I think the statewide registration database is much more accurate than relying on the old paper forms.
Here, thank you.
So the next one that we would propose changing is NC. So that's sort of like one of the previous ones that we discussed, OC, where they don't put a name of a city or a township or something else that we can accept, like a village. We currently would say NC for no city there. We would just propose making this part of the invalid city or township or IC code. However, we do recommend repurposing the NC so that it is used for a different purpose, which is non-existent county, which we see sometimes where somebody will write a county that doesn't exist in Michigan and that being the circulator in this case, not the signer, will put, Orange County or some county that doesn't exist in Michigan. We're not kicking people for misspelling a county, but if they put a county that doesn't exist in Michigan, or if they put the name of a city or township instead of a county, that would be a non-existent county and that those sheets would be rejected. We have and would recommend continuing to count signatures if they leave the county blank, but not if there are multiple jurisdictions from multiple counties on the form. So for example, there's an example in the memo where if there's 6 from Detroit and 4 from Lansing, we would treat that as a Wayne County form, even though they didn't write Wayne, but the Lansing ones would not count. And if there's 3 each, 3 Detroit, 3 Lansing, and 3 Ann Arbor, we wouldn't count any of those because it's not a county form for any of those counties. That is basically how we would treat those.
So the circulator you have out-of-state circulators.
Mhm.
So they're going to have, and they put their out-of-state address
Right.
and they put it out of Michigan County.
That's okay. Yeah. It's just on the header when you're using the, and if you go to the examples at the back, there should be one of these.
Or there's.
So we're talking about the heading.
Yeah, I'm sorry.
Yeah, okay.
This is the circulator is supposed to put the county at the top.
Right.
If they put a county that doesn't exist in Michigan, which is usually because they put a city or township, but sometimes because they'll just put like Orange
Right.
County or something, that would be rejected. But if they leave it blank, we will count it for the signatures that are the plurality of a county, but we won't count it for the ones that aren't because those were not circulated
Right.
properly on account. That's what we're proposing.
Yeah.
Excuse me,
Yeah.
is that portion a change to current practice of the plurality? Or does that exist now?
I think it exists now. It certainly exists now if all of them are from one county. I don't know, Adam, would you consider that a change if, like, what do we currently do with the 4 Detroit and 3 Lansing ones? Do we currently count 4 Detroits only, or do we not count any of them currently?
I think currently we would reject the entire sheet. Even if it was like 9 and 1, I think we would reject the entire sheet. And this may be, this practice is one that I will admit has been a little unclear as to exactly how it's been explained and stuff like that. So that's kind of what we want to clarify.
So it's either a change or a clarification where perhaps it hasn't been consistent to a canvassing practice. But what we're proposing here would be in that situation where it's like blank and you've got 4 Detroit, 3 Lansing, 3 Ann Arbor, we would propose just counting the Detroit ones. I think another approach that would be consistent that I think Bureau is fine with, it just depends on what the board wants to do, is you could just not count any of those if they're not all from one county.
I think that you have to do that.
Yeah.
I think you have, because that from a following the law and rules standpoint, it's not rocket science doing this work. It's difficult. You need to be detail oriented, but I think it's adding more work to that to look through. Well, it's blank and there's 6 for Detroit and 4 for DeWitt. I mean, then you're going through and adding. If they don't all match up to the county, I think the whole sheet should be rejected.
So this is a decision we're going to have to make. Right.
Yeah, I mean, if there's a clear sense of what the board prefers, we'll put that change in now. Otherwise, it's something the board will have to discuss and before we finalize the manuals.
I mean, I was always under the assumption that the county was a required element.
Yeah, I thought so too.
And I know that you could turn in something blank.
I mean, they're county petitions.
Yeah,
There was a
it's-
proposal to change that, but remember the Rebel Congressional District proposal, which would have resulted in enormous confusion. So
We think it may be from a court case, but perhaps we just need to research this and further brief the board in more detail on this issue prior to the next meeting. In terms of the blank, if it's blank, if that can be counted.
okay.
But is it, I don't want to, again, I said I wasn't asking you to vote on anything today, so I'll stick to that, I promise. But is there currently, assuming that we can count blank county if they're all within a jurisdiction, all within a county, does the board generally agree that it should only be if they're all from one county? Or is there some interest in counting the plurality, going with the plurality policy and counting the ones from the plurality only?
From seeing as I brought it up, for me, the only thing I am remotely comfortable with would be if it's left blank and everything is within one county. If it's got Wayne on the top and there's 6 and 4, the whole sheet should be rejected. If it's blank and there's 2 different counties, the whole sheet should be rejected.
My only concern would be, and I get the whole idea of if everything, let's just say everything is Royal Oak. We know that's Oakland County. We know that's what that is. But my concern is, are we inviting circulators to not follow the required elements that are needed to submit a petition? That's why I have the question of, is it a required element or not a required element? I mean, because we've already have issues already with people and circulating and things like that, but are we adding some, are we allowing something to happen that we shouldn't? I mean, we remove things because of required elements on a form and we've removed candidates. So what I've always told people is fill that out first. Don't let any signatures get on that form until there is a county on that form.
I would argue that as well, because I think to play to what you're saying, we're also watching an increase in the number of third-party for-profit companies that are doing petition gathering, may not even be from Michigan. And so by lowering the threshold, it starts everybody going down in the wrong thing.
Yeah, and when you think of if you're asked to sign a petition and somebody has, because I'm in the Detroit metro area, they might have 3 different petitions. So somebody says, okay, I've got 6 Detroit, so I can I don't have to turn to Oakland County. I can just have somebody fill in the rest of the Detroit, even if they're from Royal Oak. That shouldn't work.
Yeah.
People should follow the rules. Okay, right?
Yeah.
Okay, so we're gonna check into that
I'm
court
accounting.
decision so we can fully brief you on that and where it comes
Okay.
from. But it sounds like it's sort of there's 2 questions. One is, should signatures on a sheet with a county blank ever be counted? And then there's also, when it seems like even if there are, that the board agrees that if we do allow blank, it's only if they're all within one county, right? Is that?
Yes.
Okay. So we will research that court case and follow up with you to give you some more detail.
I'm not 100%.
Yeah, okay. Well, again, I said no votes, so, yeah, I mean, you obviously can vote, but I'm not gonna ask you. But I just want to clarify that current practice, which we would recommend continuing, is if they do write Wayne and there's 4 Detroits and, or 6 Detroits and 4 Lansings, we reject the Lansings, but we wouldn't reject the Detroits because those are on the form from the county.
If it says Wayne County.
Right.
And you
Yeah.
got 4 Detroits and
So,
snuck
yeah.
in some Lansing people, not Lansing.
The
people.
Lansings
Right.
get
Yeah.
rejected, yeah.
This is
Okay.
only
That's
addressing.
current practice.
That's
Right.
Yeah.
Okay.
So we
They
have something
work.
for us. Okay. So so now this is a new category of changes, Roman numeral 3, these are new codes that really provide a little more detail as to why we're rejecting something. So the first one is form. This is not a code that we currently have, but basically this is if they use the wrong form. So like sometimes they use a judicial candidate use a partisan form, which they're not supposed to use, not allowed to use. And sometimes we also got like some instances like with the reproductive freedom petition and the promote the vote thank you petition, where like we would get them mixed up because there'd be circulators that would be doing both. So like when in our boxes of reproductive freedom, we got some promote the vote, which we rejected because they weren't the right petition, but we didn't have a code for that. So these are typically things that we usually call these circulator, we usually use a circulator code but I think it got confusing. So we thought that form would be just a simpler way of explaining those types of errors.
Same question, because I think I remember, there was, I think it was a judicial, it might have been a judicial candidate. There was a judicial candidate came in front of us, but their clerk had the wrong forms.
Mhm.
But I think we ended up keeping those because it wasn't his.
It was my case.
And I think, I was gonna say, I think we got
It
rejected.
was.
Yeah.
Yeah, the clerk, I mean, it was so sad because the clerk, she came and she cried. Do you remember?
I do remember.
Because she had given the candidate the wrong
Wrong
forms.
form.
And it was just because the form had changed and she was not aware of it. She
Yeah.
had. Yeah,
And so I have to admit that was before my time, but I think you're correct.
he lost anyway.
Board accepted. I thought the court overturned the board, but I'm kind of deferring to Mary Ellen if it was her case that maybe she remembers more than I do.
No,
I think
I remember Chris
Yeah.
saying that he thought that was the last time that the board would approve substantial compliance. Instead of strict, but that wasn't reversed. There was another guy who, from that same county,
And that might be
who
the
had some issue, right?
So you would use this form code if you're saying that you would use form on petitions that are not the petition that was submitted.
Mhm. Yeah, or if they use the wrong type of form, like if they used a partisan form for a judicial candidate.
Will it also apply in an instance where let's say you're running for the 11th district and for some reason you put 10th district on there? Is that a form?
I think that would be circulator, right? What would that be? A header. We call that a header. That we're gonna get to that one.
Okay.
Because that's where you used the right form, but you wrote the wrong stuff on it.
Yeah, that makes sense.
Okay.
So, yeah. Okay, so moving on, the next new code that we're proposing is MRE for missing required elements. And that's basically if there's not a required element that's on the form. Most of the time, that's because of a copying error. And there's like, we saw some of these last round, those of you who were around.
They didn't have good penmanship, so they printed it out and then tried to tape it over, which was a great idea, except then they cover the required element. Okay,
Right.
yeah, all right.
Right, exactly. That would also count as that. So if any of the required language is not there, it's a missing required element and this MRE would apply. I think, was that previously a cert or what was that? What would that be called? Or miscellaneous?
Prior has depended. In the example of like stickers or a Sharpie covering up language on the back that was required, like the text of the Constitution, that's been coded as damaged.
Yeah.
Or stickers covering up, it's sometimes like on the front, it's been miscellaneous, or it has been circ.
So
Or it's been heading if it's in the heading of the petition. So it's trying to clarify that.
So you're clarifying that when someone uses a marker instead of a pen and it on the other side removes required elements, it's removing required elements. It's not damaged.
This would apply to, if you remember last summer, we had a gentleman from Detroit. And he missed the signatures because he missed the bottom line.
Yeah.
Yes.
The copy, this would cover that as well.
Yeah.
Yeah,
And that one where it just like cut off one little point and then all of her petitions were thrown out.
So if you end up with an MRE on your sheet, what's the outcome?
every signature on that sheet is no good in that
It's a
situation.
fatal error.
Yeah, because we can't guarantee that any one of those people signed it when it had that element. So like it's possible that somebody signed it and then subsequently something was taped over, but we just don't know that. And then we will still maintain the damaged DMG code, which is similar, but that's where like there's a hole ripped out of the sheet or a corner torn off of the sheet. And
What about folding? When they fold them multiple times, we had that on a couple of petitions, so that would still be considered damaged.
No, as long as it's not like ripped in half, as long as it's not mutilated, something like if they just fold the piece of paper and then submit it to us and we unfold it and it's fine. that what you mean?
Well, I mean, I'm thinking I'm going back to. There was one that the petition had been folded a couple times. And then you couldn't see a couple of the letters on the required element in the back. So that actually would be an MRE, not a damaged.
I would agree with that.
Okay. You okay over there, Tony?
Trying to adjust my chair. Shot me down.
Speaking of damaged. So, okay, so,
Okay.
yeah, so that's how we would distinguish those.
Okay. Damage would be if I dumped my entire coffee
Okay.
on top of it, right?
If this,
Yeah,
yeah.
I'm watching the clock and
Yeah.
the window, so.
Right.
It looks like our cardinal is no longer.
I will
So far,
try to
it's okay.
summarize quickly.
You know, some of us are going east and some of us
Yeah.
are going west,
Nobody
right?
knew about those places.
Right, so,
So I'll try to go quickly with the rest of this. And
Okay.
obviously the board can review this and.
I was wondering
talk
if there
about it.
would be an F. But you're including it in IS, is that correct?
Oh, yeah, I see what you're saying. So illegible is pretty self-explanatory. That's just where we can't read what they're saying. It doesn't mean that your signature has to be nice. If you have a scribbly signature, but it matches your signature, that's fine. But otherwise, if we can't read your writing, then that's illegible. Then this is another new one, OS for out-of-state box blank. This is if an out-of-state circulator doesn't check that box for out-of-state circulator, which is a relatively new requirement. We previously called those circulator errors, but there's been a lot of situations where people couldn't understand what the error was. So this just makes that more precise.
Mhm.
And then similarly, paid volunteer, that's also a new requirement. Is the out-of-state new or not?
The out of state is
Never
not.
mind. I'm sorry, I was wrong. That was not a new requirement, but this one is. The paid volunteer checkbox, if it's not checked, we were calling this circulator, but there was also confusion about why that was being called circulator. So this would just be a more precise code that would cover that exact situation, PV. And then so finally, just three more, I'll try to get them quickly. So this is a new kind of consolidated code for invalid signature, IS. We don't currently use this. There's lots of reasons that signatures can go into this category. We obviously had a lot of what would be in this category last May when we had the problem with the petition circulators submitting fraudulent signatures. But this would just cover any reason. It's no good. Either it doesn't match, regardless of why it doesn't match, there's no signature, or the signature is incomplete, which is really just another way of saying it doesn't match. We just would combine all of those into invalid signature. And then finally, we would recommend a new code for invalid address, where somebody either didn't write an address, or the address was just like Main Street without the street number, or they put a PO box, which can't be your residential address. So we currently call these no address, but that causes confusion because sometimes somebody wrote an address down. It just wasn't an address that we can accept. So that's just I think a more precise, clear way of describing what's going on here. And then finally, we recommend it's a new code, right? Date or invalid date. This would just be any issue that has to do with dates, basically that causes something to be rejected. So either the signature is too early or too late, or missing, essentially. That would all be a date error. And previously these have been sometimes circulator, sometimes other things. We had 3 codes for them. Do you want to just explain that?
Yeah, so this isn't a change to current practice. It's just how we code it. So currently we would code if somebody writes a birth date, for example, that's early date to mean that it's outside of the window that they can circulate. If the date of the signer is January 2nd, but the circulator dated it for January 1st, that's SDC for signer dated after circulator. That means that line's invalid. And if it's blank altogether, it means no date. So the idea was just to consolidate all of those into one code that just is date, but there's an error with that date.
So that ends the updates to the codes. The rest of the memo has examples. It would have the updated chart, which we'll probably have to adjust a bit depending how we handle that no county thing, non-existent county thing. And these, we've got, examples that cover these situations with sheet images. And then at the end is a section that mostly is just the language is already in our manual, but a little bit updated about why we toss entire sheets.
Do you have anything addressing judicial candidates to make sure that they are referencing a judicial position?
Like whether it is a new judgeship and.
No, I'm actually going a little more simplistic than that. Let's go back to the removal of judicial candidate. They put down their district they were running for, but did not put down that they are running for a judicial. They put down that they're running for the 46th district, but nowhere in their heading did they say that they were running for a judicial position.
I see what you mean.
That would be header.
Yeah, so
Yeah,
that
so I'm thinking, I was looking at the header, I was like, hey, is it in there? Is it stated in the header? Is it somewhere heading? Because I see that judicial candidate seeking office in a district with a full term or partial term, but I don't see anything just stipulating that. I don't know. I just feel it should probably be in the manual somewhere that if you are running for judicial candidacy, that your petition should state that you are running for a judicial seat. We did remove a judicial candidate from the ballot because they wrote 46th district, and in that county, there was a 46th district state house seat. And so even though all the addresses were all for that district, it still wasn't clear.
So is
Having been the member who made that motion.
Yeah, we're asking judicial candidates to be very careful, and I
Yes.
think that's reasonable.
Yeah. So they're running
Agreed.
for the judicial
Right.
seat in the 46th.
If they can't get it right,
Right.
then they don't deserve to be a judge.
I just was asking. So
No, yeah.
yeah, just like noting that they are running for a judicial spot. Because obviously we don't have a judicial form.
Right. But
So
is there going to be a different form for the affidavit of identity? So you eliminate the problems that arose this morning?
Yes, we have actually released in the last couple of weeks an updated affidavit of identity form, and it eliminates the possibility that someone will not check that box because it said if you're running for nonpartisan office, it basically says I am running for the box you check says I am running for a nonpartisan office without party affiliation. So it doesn't require you to say nonpartisan office and then write in the field party affiliation none. So that should eliminate that problem. Even though it's not technically your problem.
yeah.
Yeah, but just to clarify in the current practice, if somebody writes like incumbent position, but they don't write judicial office 46th district, do we reject if they just write 46th district, or was it only in that case because there was also another 46th district?
The general rule of thumb is if we don't know where to put you. So I think it was only in that case, but it could come up as well. Where if you have like state house, state senate, district, something like that, if it just says first, third, things like that, where we don't even know. It also could come up in the same idea of district versus circuit. If you just say third, we don't know if that's circuit, we don't know if that's district. But generally, and I do know there is a case on this from Eaton County some time ago where it said if you know where to put them on the ballot, then it's okay. So I think, I think we can clarify that.
Yeah, it's just I wouldn't want to see that happen to another candidate.
Question on a different item here, just a trivia question. I just don't know the answer. In the new code you're bringing up, you have the out-of-state box. And I see what you're doing there, and that's perfect. But here's the question. Since we are experiencing a lot of out-of-state, not necessarily individuals, but corporations, companies who are in the business of doing signatures. And they may come into Michigan, they might hire you, Adam, but they actually are headquartered in Florida. Do we ever Do we ever try to figure out who those folks are? If you're checking the box as a circulator and you live here in Lansing. But if you're working for a company that's actually collecting these out of Florida. You're in effect sending them back there, or you're bringing their management people in to review what you've done. Is that something that Michigan needs to know about? Or do they know about?
They do.
So let me know if this doesn't quite answer your question. So in the circulator box, that person would still have to provide their address in the box to say like 123 Main Street, Orlando, Florida, in that example, and then still check the out of state box. As far as whether or not there's beyond that, I'm not sure what.
There's no
authority.
indication of who they're working for.
Yeah.
There never is.
No,
Okay.
because they sign as the circulator signs as an individual,
It's purely their.
not as an employee of a company. Right.
So there's nothing, I don't, and I guess I'm gonna just add on to it. Are you saying that with these out of state circulating companies, are those petitions leaving the state of Michigan and then
That's the
coming
next
back?
question, obviously, sure.
It might be. I don't know that there's necessarily a prohibition on that.
No, I don't think that.
But that might be happening, yeah.
I think things get either hand jacked into a spreadsheet or scanned, and then they might go somewhere out of state, out of country for, validation that these firms do, but
Or maybe they don't.
as we saw last year, perhaps they don't.
I will say that some of the things we're gonna propose, I don't want to get into it because we need to finalize the memo and we want to get out of here before the snow. But I think some of the things that we're looking at will help the staff and the bureau and the boards review when we get in those situations. Hopefully that never happens again. But if we get in a situation like that again, I think we'll have some better tools to deal with it.
My question was more only because, I mean, we live in a world of business, right? If you have a circulator who is a citizen, who is either a paid or a volunteer, they're working on behalf of a campaign that everybody knows and we all live in the same place. That's almost a little bit of a different one-off, as if they are a paid employee who works full-time collecting signatures for some corporate entity that may have a different agenda.
It's possible. I shouldn't say that because there may be constitutional issues. Because there have been constitutional issues about whether the circulator has to be from the jurisdiction.
Okay.
Or from the state, right?
Which is,
But I don't, certainly there hasn't been, so far as I'm aware, any effort to identify the corporate entity that employs the circulator. And I don't know whether you could do that.
it's my recollection that the out of state checkbox was a reaction to court decision prohibiting the prohibition on somebody from
Right.
circulating in a state because you're infringing on their speech,
Yeah.
whether they're getting paid for it or not. And so it was an issue of, well, we at least want people to know that the circulator is from out of state.
Right.
I can't remember, does that box have to be checked before signatures go on? So that someone would know because you don't sign the circulator box until you have circulated your petition. So I think that was the question of whether or not if they're paid or volunteer. But someone really doesn't know if that individual is actually out of state until that petition has been circulated and completed and the individual signs the certification, the circulator box. And then that check box isn't going to happen until after all of that happens. So a person who is circulating that lives out of state, no one's going to know that they do
That's true.
until after that petition is circulated and
right.
completed in the correct process. And knowing that
A circulator could put their name and address down, but not the date for the circulation. And that could give somebody the requisite information.
And then-
But it doesn't happen.
Yeah, I'm curious to see what happens with this paid volunteer checkbox. And then, if that checkbox is not checked on the top, does that invalidate the entire petition? And I'm seeing Adam shake his head, yes.
Yeah, so that's how the board with the paid volunteer checkbox, that's how we've been doing it in the last, so we had 3 petitions
Mhm.
so far that in 2020.
So that's a fatal error.
If it's completely blank, correct.
Circulation business is complicated.
Follow the rules.
Okay, well, this is, I'm sure that we're going to be hearing a lot from the practitioners about these changes, and their input will be valued and helpful. So thank you for working on this. I believe that we have completed our agenda.
I have.
Eric is going to inform us about our about what's happening with the cases.
Yes, I can. I was actually raising my hand just to revise and amend my earlier statement about the board lacking promulgation authority. I believe I was incorrect. And I had my basis for believing so is that in 1997, this board did promulgate some procedures and rules. So you do have that authority, and I said that you
Well,
did.
at
So
least
that was
nobody
wrong.
challenged their ability to do so, right?
I'm sorry.
Nobody challenged them.
Nobody challenged them. Yeah,
Right.
so, at least as
So maybe
far as
they-
it's been
yeah.
done in the past, appears
Right.
that you have that authority.
Okay. Do you have a judicial update?
I think at the last meeting I mentioned the Supreme Court has taken up I can try to remember the name. It was a challenge brought by the Committee to Ban Fracking signers. So that is now going to oral argument from the Supreme Court, and there will be supplemental briefing on some matters that the court requested. So that's a thing that's happening.
So I just have a question, is that, so if it goes through the Supreme Court and they tell us to put it, I mean, basically they either could tell us to put on the ballot or not put on the ballot? Is that where we're at? Or I don't know.
That case was at a much different stage. That case got dismissed early on the basis of whether or not the court claims a jurisdiction. And that's a lot of what the Supreme Court is interested in, is the jurisdiction of where those claims get brought.
Okay.
But yes, at some point in the future, if it gets referred back down, there may be a further discussion about whether the signatures that they attempted to submit should have been counted or not.
Okay. I think I'm the only board member left that was here when that started. I do have one question, but it's not for Eric unless Eric has anything else.
No.
So I know that we discussed this at our last meeting. Has there been a document with the required signature put out?
Like the minimum numbers? Is that what you're talking about for
Oh,
petitions and all that?
yes.
So that is actually part of this. So that
Okay.
goes out with this whole update as well.
That was my question.
Anything else?
Just that you guys did a beautiful job putting that together.
Yeah.
Very easy to read, very easy to, and great stuff. So thank you. Thank you both.
Thanks.
We have a motion to adjourn.
Motion to adjourn.
Support.
Let's stay.
Adjourn.